Today, we're putting in the spotlight the SRA's plans to modernise regulation for sole practitioners. My name is Nikki Taylor. I'm a solicitor, and I've worked in most aspects of regulation with the Law Society and the SRA. I did my training and have had other experience in working in small high street firms. I'm currently a member of the team in the SRA, one of whose responsibilities is to produce the draft new SRA handbook, which we expect to come into force later this year. Over to you, Karen.
Thanks, Nikki. My name is Karen Noakes. I qualified as a solicitor in a three-partner high street practice. I've actually been in legal regulation for the past 17 years in a range of roles, including previously having been head of the practice standards unit at the SRA.
So the format of this webinar is as follows. Karen and I will be giving a presentation lasting about 35 to 40 minutes. You can download from our website our slides, so there's no need for detailed note-taking. At the end of our presentation, we welcome your questions and comments, which can be made either by phone or by email. If you prefer, you can respond to our consultation about sole practice. We're interested in hearing your views on certain topics, and we'll be inviting you to take part in a mini poll during the webinar. So sit back, relax and enjoy and take part. And we're here to have a dialogue with you. So I want to tell you a little bit about the programme of webinars which the SRA is hosting. We're fairly new to this kind of engagement, and some of you might not have taken part in a webinar before, and we do welcome your feedback on this form of getting in touch with you. You'll be able to find recordings of this and other webinars covering a related topic on our website. We're planning future sessions, so please keep an eye on our website for details and mention this to colleagues. You might have some suggestions for webinars, and we'd be really grateful to hear from you. And our aim is to help those whom we regulate understand and prepare for the fundamental changes to our regulatory approach, which is happening over the next few months. And we think that webinars are an accessible and cost-effective way of having this dialogue with you, and they're certainly easier to get to than roadshows, and particularly if you're maybe working in a small firm. So the webinars are part of our communications and engagement strategy. All right then, so let's look at today's topic, and in summary, today we're focusing on sole practice and the ways we intend to authorise and supervise sole practitioners. I, Nikki, will explain the background to the issues raised in our open consultation, which is called Sole Practice Modernising Authorization, and which is available on our website. And then Karen will discuss, with some practical examples, our approach to supervising small firms. So first of all, let's have a look at our consultation. So this is called Sole Practice Modernising Authorization. And it was published on the 14th of December, and you'll find it on the SRA's website. The consultation closes on the 8th of March, so you've got plenty of time to have a look at it and let us have your views. We encourage feedback on our proposals, and we'll be treating the comments that we hear today as part of that feedback. And I might say that this consultation has a great virtue of being very much shorter than a very much shorter document than some of the other documents you'll find on our website. So let's think about the context of this consultation. The consultation is part of our implementation of an outcome-focused approach to regulation, or OFR as we call it for short. And it's part of our risk-based approach to regulation. And these terms are explained perhaps in more detail in our October consultation on the new SRA handbook, and also in our November 2010 policy statement. Now, Karen will be explaining about OSR and risk-based regulation and what this will mean in the context of supervision, particularly of small firms. So that will be coming up a little bit later on. But so let's go back to the consultation itself and a few words about our objectives. Our objectives in the consultation are, and as set out on the slides in front of you, but I will go through them slowly with you. So they're to achieve the same degree of consumer protection for clients of all firms of solicitors, regardless of their size and business model, and this may include an alternative business structure, or ABS. Another objective is to apply the same standards to all types of legal services providers, so far as is justifiable from a risk perspective. Further objectives are to deliver operational effectiveness and efficiency for the SRA. Now, operational effectiveness and efficiency will eventually reduce the cost to the regulated community and ultimately to the clients whom we serve. And another objective is, as we mentioned before, to be outcome-focused and risk-based, both in our handbook requirements and in our regulatory processes. And again, Karen will be talking a little bit more about supervision in a little while. A further objective is to facilitate transition between the different statutory regimes, i.e. from moving possibly from being a sole practitioner to being a firm or possibly an ABS. We see this as being a key benefit of the proposals which are contained in the consultation paper. And I suppose our overall objective really is we're trying to harmonise our regulatory requirements unless there are justifiable reasons for differences. So I want to have just a few words about our existing decided policy, and these points are not the subject of the consultation, but I think they serve as a good background against which the consultation is taking place. So we plan that all firms, not just sole practitioner firms, should be subject to appropriate scrutiny and assessment at the point of authorization, i.e. that's when they are established, and on an ongoing basis in the public interest. We have also decided that all firms will be required to provide us with a wider range of information annually and periodically, because without this we can't really operate a risk-based approach to regulation. And thirdly, we have already decided that all firms will be required to appoint a compliance officer for legal practice, COLP, and a compliance officer for finance and administration, or a COFA.
Yes, Nikki, and this may mean that a person in sole practice effectively has to wear different hats when carrying out the COLP and the COFA roles. But people may realistically be carrying out these roles now if they're actually managing their practices effectively.
Yes, Karen, I think that's spot on, absolutely. So the regulatory burdens on firms should be proportionate to the risks they pose, and firms should not be subject to unnecessary regulation. For example, we propose removing the need for all firms to renew their authorization or license annually and replace this requirement with a requirement for information and a fee collection exercise.
Yes, Nikki, it's certainly the case that we will need more information from firms, and this will be key, because without this increased information, we will not be able to assess risk appropriately and use our resources wisely.
Thanks, Karen. Yes, that is so right. So the proposals will mean lifetime licences to run a firm, whether the firm's a sole practice or a partnership. So let's have a look at what actually is proposed to be changed by the consultation. The consultation is largely about the technical means of achieving the harmonisation of the currently different regulatory approaches to sole practitioners as compared with other firms and in future ABSs. The SRA's powers are contained in different statutory provisions, and these need to be amended by means of a statutory instrument. And this is what the consultation really is focusing on. So it's focusing on the mechanism of authorisation of sole practitioner firms and the mechanism for taking certain regulatory steps. So now we're going to look at both these mechanisms in a bit more detail. So what's changing? We're looking at the mechanism for authorisation of sole practitioners. Regulation of sole practice is currently governed by the Solicitors Act of 1974, as amended particularly by the Legal Services Act 2007, and recognition as a sole practitioner is currently obtained by way of an endorsement, not a very happy term I always think, an endorsement on an individual's practising certificate, or PC. We plan that from 31st March 2012, sole practitioners will be included in the definition of recognised bodies and will be regulated just like other firms under Section 9 of the Administration of Justice Act 1985, and in a similar way as ABSs will be regulated under the Legal Services Act 2007. So this means that sole practitioners, like all other firms or recognised bodies, will be given an indefinite licence once we've authorised them. Okay, so the other mechanism which it will be changing in accordance with the proposed order will be the mechanism for the SRA to take certain regulatory steps. Currently, regulatory steps against sole practitioners are taken in respect of the sole practitioner's practising certificate, i.e. imposing conditions on the practising certificate. Under the proposed new scheme, the regulatory steps can be taken against the authorisation of the sole practitioner's firm, just like every other firm. So, you'll probably be asking yourself, particularly if you're a sole practitioner, well, what's this actually going to mean for me? What do I have to do when the new regime comes into force? Well, you'll be, I think, delighted to hear that existing sole practitioners will be passported into the new authorisation regime in March 2012. So that, I'm pleased to say, is that the transition should be fairly painless for the sole practitioners and arguably the SRA too. So let's have a look at how we're actually making these changes, what will happen after the consultation. The Legal Services Board, the LSB, the new overarching regulator of frontline legal regulators like the SRA and Bar Standards Board, has power to make recommendations to the Lord Chancellor under Section 69 of the Legal Services Act that the Lord Chancellor should make an order to amend the primary legislation as necessary to achieve the changes that I've just discussed with you. A proposed draft of the Section 69 order is annexed to our consultation paper, and you'll find it as Annex 1. It's possible that the draft Section 69 order may change a little. The new authorisation regime for sole practitioners will also apply to registered European lawyers or RELs, who are sole practitioners. Roles can be a sole practitioner in the same way as sole solicitors can be sole practitioners. So similar changes are expected to be made in respect of those. Now we're going to have a look at what impact the proposals may have on, for example, equality, costs, competition and related issues. The Section 69 draft order proposes a change in the way sole practitioners are authorised, so they become authorised and regulated in the same way as other traditional business models, partnerships, LLPs, incorporated practices and ABSs. We consider it's important to have fairness and consistency to ensure an appropriate level of consumer protection. So please could you have a look at our draft impact assessment, which you'll find as Annex 2 to our consultation paper. In summary, we think that the Section 69 order will have minimal impact in terms of costs to firms, and that any impact is outweighed by the benefits to firms and the SRA. On competition, we think that the impact will be positive. We consider that sole practitioners and firms benefit from the removal of a requirement for annual renewal of their endorsement on the PC, and this will allow for easier transition when changing from one business type to another. But we want to know whether you agree with this assumption. If you don't, we'd be very pleased to hear your reasons. On equality, we do not consider that Section 69 order, that the changes thought about by the order itself will produce any adverse equality impact, but we would like to know whether you agree with this. And if you don't, could you please let us have your reasons in your response to our consultation, or possibly today, if that suits you better. We are aware that there are concerns about what the actual authorization requirements will be, and a separate equality impact assessment is we're carrying this out on the new authorization and practising requirements section of the new handbook. But we would like to know whether you consider that the proposed changes will have other benefits for sole practitioners. I've already mentioned the ease of transition from one business model to the other, and if so, we'd like to know what these might be. Equally, we're eager to know if you can think of any adverse impacts, particularly on any equality group. If you do, please could you have a think. If you do, please could you let us know what you think this impact will be, and also how you think we could mitigate the adverse consequences. Now, we're going to have a break at this point, and we're going to have one of our mini polls. And the question is, do you agree that the proposed changes to be brought about by the draft Section 69 order are unlikely to have any adverse equality impact? So vote yes if you think they're unlikely to have an adverse equality impact, and no if you disagree with the statement. And the votes are coming in now, and I think at the moment we are topping them up and still coming in. Still changing. Still. Right, I think that's fairly stable now. So the results of that are 37% of people, 36% of people think that the order is unlikely to have any adverse equality impact. But 16% think there may be an adverse equality impact, and so we're particularly interested to hear what that impact might be, and so I do encourage you please to let us know of your concerns. And frankly, not surprisingly, 47% really don't know. Well, that's quite a respectable position to have, and there's nothing wrong with that. Thank you for taking part in that. So carrying on just briefly with the consultation, what happens next? Having reviewed the consultation responses, the LSB will then determine whether it's minded to recommend a Section 69 order to the Lord Chancellor. So essentially then the LSB will take over the reins. So if it decides that it wishes to do so, it will conduct a short consultation, and that's expected to take place during May. And now we'll hand over to Karen, who's going to talk about supervision. Karen.
Thank you very much, Nikki. Supervision is about the oversight of all of our regulated firms. It is about us as the regulator ensuring that individuals and firms meet the appropriate standards that both the public in general and the individual clients expect. Supervision must be flexible, and importantly, it must be risk-based. Flexibility is the key to ensuring that we regulate effectively in the public interest. So, resource at the SRA in terms of supervision must be applied based on risk. We all know that the legal marketplace is in a period of great change. So at the SRA we must use our regulatory resource very wisely. So looking at the general principles, supervision will be based on constructive engagement with all shapes and sizes of firms. What do we mean by this? Constructive engagement is about having a meaningful dialogue with individuals and firms. It is about taking information which we already have or information which we will gather in. It is about us using that information to assess risk and then engaging the firm or the individual in dialogue about any relevant issues. Supervision is not about catching firms out. We understand at the SRA that in moving to OFR, firms will be getting to grips with a new handbook. For example, they'll be looking at the principles and the outcomes and how they can meet those. And we understand that for many firms, this represents significant change. Our approach is not to nitpick or to tick box. It is about us moving away from a heavy focus on the exact processes that firms have used to comply with our rules, to looking at whether outcomes are being achieved. And the benefit of OFR for firms is that firms will have much greater flexibility in how they achieve those outcomes, and importantly, how they achieve those outcomes for clients of the firm. So supervision will focus on how firms manage their own risks. And by this, I don't mean that we'd be looking to have complicated processes in place. What we mean there is good business management. The sound financial management with aspects of business planning. We'd be looking at firms who ask themselves, what are my risks and how can I deal with them? So moving on to risk. All regulated firms will be supervised according to risk. We set out in our November policy statement, which is available on our website, our risk-based approach. We will seek to identify the risks to us as the regulator in us meeting our regulatory objectives. And that emphasis there is key to understanding our risk-based approach. So if you haven't already read the November policy statement, I would really urge you to do so. The assessment of risk will be used to increase scrutiny in our authorization of new firms, and as I've said, in our allocation of supervisory resource as well. But as Nikki said, that risk assessment is reliant on information. So in order to analyse and assess risk, we will use information from a range of sources. including stakeholders and firms. And in that regard, we will need more information from you. We will therefore require information from all firms on authorization, by virtue, for example, of notification requirements in the draft code, and I'd refer you there to the requirements in Chapter 10 of the draft code, and also as part of an annual reporting process. But we at the SRA also know that we will always need to respond reactively to some risks and events. This is inevitable, and it's right and proper that we do so. But we will focus on only reacting to events and risks which we think are of regulatory concern. And this will also enable us to use our resource in proactively dealing with emerging risks. So in respect of the range of supervisory approaches, what will they look like? Supervision will still include us visiting firms. This could be as a result of responding reactively to a notified event, or as part of a proactive program that we put in place, looking at a type of themed risk. For example, we receive a number of complaints about a certain area of a firm's work. We will visit the firm to find out what is going on. Why are the clients complaining about just a certain aspect of the firm's work? We'll look across the firm in terms of whether you're achieving the outcomes. We may also make periodic visits to certain firms, only if we think there is a risk basis for doing so. We will also undertake desk-based supervision. So this means that we will use the means of telephone or email contact to engage with you. Again, this may be in response to an event which has occurred or to an emerging risk which we have identified. For example, looking at some of the notification events in Chapter 10, we would telephone you to discuss the matter. We may ask you for some more information, or we may refer you to useful information on our website which could assist you. The emphasis here is about constructive engagement. It's about a meaningful dialogue, getting to know you and your firm and dealing with the issues in a risk-based way. Supervision, as it is based on risk, will vary across our spread of regulated firms. So for firms we consider to be low risk, a firm's experience might be termed as low intensity, and again I would refer you to the November policy statement where this is set out. So what would this mean for low risk firms? It would mean that we at the SRA would only contact you when we needed to. That low risk firms would not be subject to periodic inspections. And any contact that we have with you would be driven by the risk assessment of an event or as part of one of those themed risks which we have identified. So for small firms, I think some examples here might help. Say, for example, if we receive information about a client who's having problems in contacting a fee earner within a firm, maybe we've had more than one client who said this. In the past, our approach might have been to write to you and raise those concerns in a formal letter, and we would therefore have been looking for you to respond to us formally in writing. There may be times when we might still need to be this formal, but in this example I've just given, we would want to telephone the firm. We'd be looking to try and ascertain what the issues actually might be. We might email you with the queries we have. We want to engage with you about the matter. So this could include in this example asking you about the follow-up contact that you've had with those clients, asking you whether those clients were then satisfied, asking you whether there were any lessons you could learn from the experience, and again, if necessary, we would point you towards useful information on our website. For themed risk, for example, we may want to take a closer look at newly established firms. Perhaps we might want to concentrate on looking at how new firms set up the processes and controls that they need to manage their own risks. So we could look at how, in certain firms, the COLS and the COFA roles would be carried out. I hope you found that helpful. And I think, Nikki, we now have a second polling question at this point.
Yes, thanks, Karen. Yes, indeed we do. And it should just be coming up on your screens now. Do you intend to change from being a sole practitioner to become a partnership, LLP, incorporated practice, or ABS within the next 6 to 12 months? So we'd be very grateful if you could indicate what your plans might be. And the answers are coming in now. And yes, there's got quite a lot of activity there. They're still coming in.
I think that they stabilised.
I think, yeah, I think they are. Right, well, the results, 61% are saying that no, they don't have any intention of changing business model at the moment. And after that, the next highest is 21% don't know. And the next highest is 8% think that they might want to maybe go into partnership, and 5% are considering becoming an ABS, and 3% an incorporated practice. Well, that's very interesting. Well, thank you all very, very much. That's very useful.
So going back to the consultation, when is the deadline?
Cam, it's the 8th of March, and we really do encourage responses. We do want to hear from you, and particularly on our impact assessment. And now, I think it's over to you. Are there any questions? I think we've got a few coming in, and do feel free to phone in if you would like to.
Okay,
Karen.
Yes, Nikki. I've actually had a question via live meeting come in respect of visits to firms. We've had a question in respect of a sole practitioner who's asking whether the visits under OFR will be like those carried out by the practice standards unit that had a recent visit from an advisor. I think whilst the basic format of the visit may be similar, we really would be looking to try and narrow down our focus again based on risk. So rather than trying to cover quite a wide range of information in a firm within sort of 1 or 2 days of a visit, we would be trying to tailor that really to what we think the areas of risk are, either because we're responding to an event, Nikki, which has occurred, or either because it's part of our looking at themed risk. So really it's about sort of tailoring that particular visit and using our time and resource wisely, because, as we appreciate, firms are very busy, and it's about making sure that we don't impact upon their time.
Yes, and it's about us all working together, really, ultimately, for the users of legal services.
Absolutely.
Right, now what else have we got coming in? I think there's some... So,
I think we have a question, Nikki, which is actually a question which has come up at quite a few of the other forums that we've been running as well, in respect of how do we decide what is a low-risk firm. Again, I talked about the November policy statement, and it might be useful to refer you to that, and especially paragraph 39 of the November policy statement, if you want to have a look at it after the webinar. That explains about our approach at the current time to assessing risk. So we'll look at those, the impact and the probability in terms of risk. And of course, looking at that now, we're working on the information which we already hold. So our approach to risk is currently being developed, and we will be looking to have the assessment of risk then drive the activities. So we will be deciding what a low-risk firm is based on the information that we currently hold, and we will be looking at both impact and probability in that assessment of risk.
Yes, Karen, I think that's quite right. And we've had another question asking, will greater flexibility lead to greater risk? Well, I think we see it may lead to different kinds of risk, but flexibility, I think, is something which is absolutely fundamentally required for the changing legal marketplace. We have ABSs, which are about to be, well, we expect to be with us October this year, and the consumers are looking for new ways of delivery of legal services, so flexibility may create different risks, but we think that these are manageable. Will training be provided? Well, again, we would encourage you, please, to keep an eye on our website. We are aiming to provide a variety of resources to assist and support the regulated community. At present, we have various documents, we have videos, we have previous webinars, and frequently asked questions and the like. And we know that there will be other training organisations providing similar training, and also I think the Law Society is playing its part in.
Yes, that's right.
So, Karen, I think you've got a question there.
Yes, we've got a question asking whether we consider that sole practitioners are more risky. Going back to my previous comment in respect of we would be looking at the impact in respect of assessing risk. Now, as I said, that in our starting point for risk is looking at the impact of the fund in the FRA meeting its regulatory objectives. So it is likely, in the kind of models that we are looking at now, that wouldn't place sole practitioners in a high-risk group because of the size of the firm. And we've also got another question in respect of, are sole practitioners' areas of work, for example, conveyancing work, more risky? This is part of the work that the Risk Centre team are looking at in respect of different areas of work. We know that there have been in the past some difficulties in the conveyancing arena, and some risks do stem from that. But it is part of ongoing work that the risk team are doing in looking at different areas of practice and also different areas of practice within different shapes and sizes of firms.
Absolutely, Karen. I think that's quite right. We've got another question here as to what additional disclosure requirements are needed. I think this goes back really again to how we assess risk. And I think really that exactly what extra information will be required, this is still under development. But we will be looking at all areas of activity and the connections that owners may have, and the particular client base they serve. Anything which might be seen as a risk factor, we will want information about.
Yes, Nikki, we've actually had another question on that topic, and the question is, will information required by the SRA be easy to provide? I think, firstly, what I should say about the information which we will require from you, we are still looking at what the content of that should be. But the guiding principle that we have is that we will always be transparent about the reasons as to why we require information from you. And we will also only ask information which we will then go on to use. And in respect of the improvements that we will be getting in IT at the SRA, an important point to make as well is that we will be expecting to gather this information online. And we are very keen also, as indeed are all of our firms, to make the process as easy as possible, and to also give you as much notice as possible to make sure that that information is readily available.
I think probably we should add that we aim to be a proportionate regulator.
Absolutely.
We know that serving clients is an important but also time-consuming activity, and we are not in the business of asking you to do things for no good reason. We've got another question here. When will the consultation results be out? Well, the consultation closes on the 8th of March, and I expect that we would get a report published probably it's hard to say exactly, but probably certainly within a few weeks of that. The next steps after that is, I think as I explained, the LSB will look at the responses, and then essentially they will take over the reins and will decide whether or not to recommend to the Lord Chancellor the making of a Section 69 order. Right, we have another question here. Well, I think it's really a comment that this is a very new way of working. I think that's the outcome-focused regulation. How prepared is the SRA for this? Well, I think it's fair to say that there's been a huge amount of change and preparation going on at the SRA, and that will continue on an ongoing basis. We are confident that we are well prepared to regulate in an outcome-focused and risk-based way, and we are keen to engage with our regulated community. We see huge value in that, both for us and for the regulated community, and indeed for clients.
And I think, Nikki, it might also be worth pointing the audience back to the November policy statement as well, in respect of, there is some information in there in respect of getting our staff ready for the change too, in respect of the processes that we are undertaking, both in respect of the structuring of our organisation, but also in the assessments that we're putting our staff through.
Absolutely.
To make sure that actually our staff are ready for this change as well.
Absolutely. Now, I understand we have some callers on the line. Is that right?
Thank you. If you would like to ask a question, please press *1 on your telephone keypad and wait for your name to be announced. If you wish to cancel your request, please press the # key.
Okay. We welcome your calls, and we'd be very grateful to hear from anyone.
I think in the meantime, we've got another question that's just come in about, it's based on cost, and it's sort of how much will this cost? Will there be additional cost implications for regulated firms arising from the changes?
Well, we have carried out an indicative cost-benefit analysis. This was published with our November 2010 policy statement. This will be an ongoing process, and obviously cost is terribly important for a number of reasons. But we don't think that there will be cost impacts on firms. That seems to be the way things seem to be pointing. So far as the SRA is concerned, yes, there will be efficiency gains, and certainly by having one process or similar processes for sole practitioners and other firms. And as I mentioned before, the efficiency gains will then be seen by the regulated community and ultimately clients.
And I think that we've just had a question come in about what is the benefit of changing the structure to an LLC?
Well, I don't think we're necessarily suggesting that one structure is any more beneficial for another, but I think really this is about flexibility, and the firms must decide for themselves as to what is the most appropriate practice model for them to adopt. I don't think we're advocating, and certainly I don't think anyone should assume that that anyone is suggesting that there should not be sole practitioners. That's not the case at all. So I think we have another question coming in now.
Yes, will the new regulations taking account of risk management have any bearing on insurance premiums? Well, I think that's very difficult for us at the end.
Because ultimately it is an open market, so far as premiums are concerned, and well, the insurers will certainly be looking at risk. So I think that risk will ultimately determine the premium. Sorry,
it's a very hot topic, as we know. In fact, we held a webinar on the topic of indemnity insurance last Friday. I'd just like to remind the audience that we have an open consultation on this topic at the moment, which ends on the 28th of this month. So in respect of any comments that you have regarding this, then please do respond to that consultation, which ends on the 28th of this month.
The future of financial protection for clients, I think, is the title, or something similar.
Yes, yes.
Right, any more questions?
We've got a question that's just come in, Nikki, about what about sole practitioners with shareholding in overseas law firms?
What about that? I'm not quite clear, Karen, what that is actually driving at. But I think if there's a little more clarity there.
I think we've got a little bit more clarity on it. So the sole practitioner is a shareholder in an overseas law company in the United States. How will this affect me if I register a branch office in London? Is that something that we can take still? Is that one?
I think that's something we
take that away with us?
Yes, I think so, and we'll publish the responses to frequently asked questions.
Yes.
I think.
Yes, it will.
So any phone calls? Anyone on the line there?
Yes, we have one question. Your question comes from Sheila Griffith. Please ask your question.
Oh, hello. I'm working as a compliance consultant and have quite a few sole practitioner clients in the southeast areas. I'm particularly interested in what you're doing, as I used to work for PSU as well. So I'm quite pleased to see what you're doing and to see that the PSU visits are going to be more focused and not so wide-ranging.
Yes.
I think that's an improvement. But what I wanted to ask you is a bit more of a sort of technicality, really. Could you just clarify for me, did you say that the Section 69 order is to amend primary legislation or to create a statutory instrument?
Well, the Section 69 order will, that is a statutory instrument by which we will be amending the government will be amending the primary legislation.
Okay, right, thanks for that.
And the Section 69 order, the draft one, is set out in our consultation paper, Annex 1. So do have a look at it. It may change between now and if it is eventually made.
Yeah, I haven't seen it.
Please have a good look. You've got plenty of time to respond. As I say, it's not until the 8th of March. So any comments very gratefully received. Thank you.
Yeah, okay.
Okay.
Okay. Further questions?
Oh, yes, okay. Is that okay? Right. Well, I think we've come to the end of our feedback and questions. I'd really just like to thank you for joining us today. Karen and I have very much enjoyed this experience. It's a first for us both, but it's been very, very valuable. And thank you for your comments and your questions, all of which will be considered and taken into account in designing our new approach to regulation. Please, again, I say keep an eye on our website for news, information, frequently asked questions, help of various sorts. We do hope you enjoyed your lunchtime session with us, and please let us have your suggestions for any topics. And please visit our website and email any comments to our briefing practice at sra.org.uk website. So finally, it's goodbye from me, Nikki,
and it's goodbye from Karen. Thank you very much for joining us today. Thank you.
Goodbye.